Did you know that if you are in a relationship with someone who's already in Australia with a work visa or a temporary visa, you might be able to come and join them without having to go through a very deep analysis by the Department of Home Affairs, and you could be joining them as their family members. So in this video, I'm going to unpack the concept of subsequent entrant visas for partners, spouses, and children. Ciao everyone, and welcome back to our YouTube channel. I'm Anonora, I'm the registered migration agent leading Green Wings Migration in Perth, and this is our YouTube channel where we discuss on a regular basis the most important, the most common, the most curious topics about migrating to Australia. Today's video is going to be about subsequent entrant visas. Subsequent entrant is essentially a visa that can be obtained by people who belong to your family. And this is particularly true for partners, spouses, and children. So if you come to Australia and you obtain a certain visa, we are going to describe what these visas are, you might be able to bring your family with you at the same time that you apply, or maybe later on. The fact that you don't apply together with your family, it depends on various factors. Some of them depend on you, some of them depend maybe on your employer. The most typical case is where you come to Australia to work on a sponsorship visa subclass 482, and your employer tells you that you are not allowed to include your family until you pass the probation period with them. This is very common, especially when you work for a business who's going to pay for your family costs of bringing them here. So they're very generous. They definitely spend a lot of money in order to allow you living in Australia with your family. But right enough, they ask you to pass the probation period. So they are sure that you are a good fit for the company. So they are sure that you're going to stay long term. And they also know that if your family is here, obviously you're going to be more inclined to stay and work for them because you will feel better on a personal level. Kind of visas that do allow to file a subsequent entrant visas are primarily temporary residency visas. I'm talking about 500 student visa, 482 sponsorship visa, 407 training visa, 485 postgraduate visas. These are the most common. You might also include family members in a 494, which is a provisional visa, and a 491, which is a skilled provisional visas. Some of these options also allow for family members to be included after the application has been lodged, but before it's decided by the government. But just be aware that this is not the case for students and sponsorship visas and 407 training visas. So if you hold one of these three options, then you will need to file for a separate application for your family to join you after your visa has been approved. You cannot include them while you wait for the visa to be decided, unless obviously you are in Australia, you have a newborn child. This is totally a different scenario. So if you are in Australia on a temporary visa 500, 482, 407, and your newborn is born, it gets automatically the visa that you already have. The most common scenario that we come across is when a visa holder would like to include their partners. So we need to understand who we mean as a partner. As you might know, if you follow previous videos, you know that Australia considers two kinds of relationship. So we might have spousal relationship when you are married to the other part, or de facto relationships. And in terms of de facto, depending on the state where you live, you might be able to register your relationship with the government and obtain a proper registration certificate, or you might have to demonstrate that your relationship with your partner has been ongoing for at least 12 months, meeting certain criteria, before being able to declare yourself as de facto partners for migration purposes. This concept of duration, it varies depending on the visa that you want to apply for. So most commonly, if you are applying for a 500 visa, for example, you will need to show that you've been in a relationship with your partner for at least 12 months before being able to include them in the application, unless you are married or you register your de facto relationship. However, this doesn't apply to 482 visas, for example, where the relationship can be in place for just 6 months in order to be included. On this point, officially, you have to be aware of the fact that by legislation, there is no set time frame for relationships to be considered de facto for 482 visas, but it's common practice in the industry to consider at least 6 months to be a sufficient amount of time to be able to claim that you are indeed committed to each other as partners. But then again, if you are married or if your de facto relationship is registered and the certificate of registration is accepted for migration purposes, then you don't have to worry about any kind of timeline. You can apply whenever you are ready. The registration certificate, please make sure that you check whether the state where you reside produces certificates that the Department of Home Affairs accepts as valid for migration purposes. Because, for example, we are based in Western Australia. Although you can theoretically register your relationship in WA, that registration is not recognized for migration purposes. So you really need to check beforehand what kind of documents you'll need to obtain in order to be able to proceed with a subsequent entrant for your partners, because in certain states, your relationship should have been in place for a longer amount of time in order to lodge a valid application and an application that can actually be approved. When it comes to children, it's important to understand that their age has an impact on the kind of visa that they can obtain. So normally the rule of thumb is that if they are minors, they can be included in any visa with not too much burden of evidence beside being, evidence that they are your children, so your birth certificate. And maybe if they are children of a previous relationship, the non-migrating parent needs to give their consent for this child to migrate with you and with your new partner. If these children are adults, so let's say between 18 and 23, it's a little bit more complicated, but still possible. Obviously, in the world that we are living, a child that is an adult child at 18, 19, they are more likely to be still dependent on you as the family head. And this is especially true if they go to university, for example. So you pay for their tuition fees. They may have a little side job, but it's more for pocket money, not to pay for their essentials. Their essentials like accommodation, food, shelter, clothing, you provide these to them. So in this case, the Department of Home Affairs still considers these children as being dependent on you. And when the dependency can be established, then the adult child can be included in the application that you lodge or as subsequent entrant to the application that you have held. If the child is above 23-year-old, in most cases, there is no option. So they would be able to be included if they have certain impairments, whether physical or mental, for which they remain dependent on you because they cannot live an independent life. But when that's the case, obviously there are health implications that need to be considered. So a child that cannot have an independent life, yes, on a certain perspective, it can be included in the visa, but from another point of view, they might be refused that visa because they are a cost health-wise for the Department of Home Affairs. When the child, as I said, it's obviously a minor, no problem at all. When you have a newborn, you need to make sure that you know what's going on depending on where your child is born. So if they are born in Australia and they are born while you're waiting for a visa to be approved in your name, you only need to notify the department that you have had the child. They will include them in the application that's pending. There won't be any application fee to pay, and they will be granted the same visa that you ask for once your visa as the main applicant has been granted. If they are born in Australia and you already hold a visa, by operation of law, they are taken to have applied for the visa with you. So it's just a matter of informing the department that this children is born and they will issue the visa for the baby. However, if the child is born overseas, the situation is completely different. So a child that is born overseas does not automatically get any kind of visa. It needs to be either included in your temporary visa or it needs to apply for a child visa if in the meantime you have obtained permanent residency. If you are a citizen and you have a child born overseas, then you should be able to obtain evidence of citizenship by descent. So just check the circumstances that apply. Maybe double check with the migration agent, obviously, to make sure that you're doing the right thing for you and your family. So what I prepared here is a list of the most common mistakes that occur when people apply for family visas to be included, like subsequent entry visa. First of all, assuming that all visas allow for subsequent entrant is the biggest mistake. That's not the case. The department has put in place some restrictions for reasons that could be considered arguable or not. This is not the place to discuss that, but not all temporary visas can have subsequent entrant applicants. Most common would be the visitor visa. So if you come to visit Australia, even if you have a 6-month-old child, that child will need a visitor visa in his own right and in his own name. If you are applying as a partner or for your partner, then the most common mistake is to not provide enough evidence of this relationship. This is especially true for married couple, surprisingly. So married couple normally think that, oh, because we have the marriage certificate, that's all it takes for us to get a visa together. That's not necessarily the case. If the certificate was the only thing, then we could have a plethora of people getting married just for the sake of visas. So that's why the department still asks for additional evidence. The fact that you live together, the fact that you share finances, the fact that you present yourself as a couple, to family, friends in the society. So make sure that you know what kind of evidence you need to give besides the basics, which is the marriage certificate or the de facto registration certificate. Delaying an application for too long is also what may lead to refusals. One of the most common things could be, for example, if you come on a student visa and you come by yourself and your plan is to study for 2 years, and then towards the end of the student visa, include your partner to bring them here so that you can apply for a postgraduate visa together. I don't really think that's a smart move, okay? So yes, indeed, you save the money for the insurance rather than applying as a couple, because your partner to be included in your student visa will only need to pay the small portion of whatever is left on your visa in terms of pro rata insurance. But at the same time, that visa can take longer to be approved than the actual time you have available if you leave it for too long. So if you plan to bring your family in Australia before applying for your 4A5 visa, do it soon enough. And soon enough for me is at least after you complete the first year of your principal course. Sorry, the first year of your study plan, okay? So you have at least 12 months time for the DHA to decide on your partner visa to be included in your active 500, and then most likely than not, you will be together in Australia when the time comes to apply for the 4F5 visa. Something very important is also to understand what rights and what obligations your subsequent entrant applicants are subject to once they get to Australia. And this is visa specific. So then again, if they come on a 500 visa, they are normally restricted to part-time working rights throughout the duration of the visa, unless you are enrolled at a master by research. So if you are enrolled at a master level course, then your family can actually work on a full-time basis. If you are here on a 407 though, that's different, because that family member will always be with part-time working rights. The 482 dependents, they are, I think, one of the luckiest people in Australia, because they really have no obligation but to have always an active insurance, which you will have anyway, because it's also part of your visa conditions. So your partner can come as dependent on the 482, working full-time. They could enroll and study full-time if they wanted to. And actually some schools, some institutes, they do offer a little bit of a discount on the courses fee for 482 dependents, so that's not bad. 494, again, super free. I mean, they're subject to the regional location. 494 and 491, they are regional options, so the whole family needs to be living, working and studies in the regional area where the visa was granted in order to accrue the eligibility criteria for permanent residency application 3 years down the track. Your partner can work on a full-time basis if you're studying a master, but that also extends to the PhD. So masters and PhD students have family members. The family members can work on a full-time basis. And then the last thing that I want to discuss with you is what happens when a subsequent entry is not possible. Because as I said, sometimes that avenue may not be available. And this could be if you're already on a permanent residency visa or if your children are adults. So if you're already on a permanent residency visa and you want to include a partner, you will have to file for a separate partner visa, subclass 820, 801 or 309, 100, depending on the location of the partner. And if you have children that you want to include after you have obtained a permanent residency visa, then you will need to lodge a child visa for them. This could be the case, for example, if you were in a relationship and you have children from that relationship, but the children of that relationship didn't migrate with you because you split with the other parent. But now you have come to an agreement where obviously having the children or giving the children the possibility to come to Australia and become permanent residents here is a huge opportunity. So you can lodge a child visa request for them. Disclaimer, when it comes to child visa, the processing time is fairly long. So we are talking about even up to 3 years. So I always encourage my clients to discuss beforehand with the other parent if they decide to come to Australia to open a door for their children, because I think it's always a good opportunity, not necessarily to give, but at least to discuss it. So, if you find yourself in Australia and you are willing to have your family joining you, they might be able to do so if they are your partners or if they are your children. This is especially true if you hold a temporary visa, the most common options being 500, 407, 482, but also 491 and 494. And if that's the case, definitely book a consultation with a registered migration agent, explain your situation so the professional can evaluate your real options to have those family members here with you and together help settle down in Australia as a family. Alright guys, that's it for today. Thank you so much for being with me in these new episodes. If you want to know more about what we do, if you think that we might be able to offer you services that you might need, please follow us on our social channels. You can find us on Instagram, Facebook, YouTube, LinkedIn, you name it. We are really everywhere. Not TikTok. Don't ask me to do TikTok videos. I don't like that.